A very good morning. I'm Victoria Sabia. Welcome to the breakfast meeting, of course, with Labor Day just around the corner. Today's conversation is very timely and very important as well, especially for you and myself as if you're an employee or a worker in some kind of way. So we are unpacking employee rights and what every worker in Uganda should know and should understand and claim as well under the law. Now, joining me this morning is Mr. Samuel Mugisha, who's acting registrar of the Legal Education, Public Affairs and Research at the Judicial Service Commission, the body mandated to promote awareness of the law and justice in Uganda. Mr. Mugisha, you're very welcome.
Thank you, Victoria.
Yes, absolutely.
And good morning, viewers.
You are very welcome. Now, let's get straight to the basics, actually. Let's start it over there. Who is actually considered an employee under the law, under the Ugandan law in particular?
Thank you very much. But would you allow me to let our visitors know where I'm coming from?
Yes.
Yes, I'm coming from the Judicial Service Commission. As Victoria has said, one of our functions is to prepare programs and implement them for the education and dissemination of information to judicial officers and the public about law and administration of justice. And we are located at Kingdom Kampala, 8th floor, and we have a toll-free number if you might want to call, which is available during working hours and working days. That is 0800100221, or you can visit our website www.gsc.go.ug. That's just in case we don't get time to let our viewers know. Yeah, thank you very much. I'll go straight to your question. Who's an employee?
Especially under the Ugandan law.
Yes, certainly we are talking about employment in Uganda, and an employee, according to the Employment Act in Uganda, is a person who has entered into a contract of service, and this is not limited to, he may work for the government, he may work for a parastatal organization, or a local government, or any other authority, but it excludes a person who works with the Uganda People's Defense Forces. Don't ask me why, that's the law. So anyone who has a contract of service in Uganda, excluding members of the UPDF, is an employee. Yes.
Okay, so it sounds like there are categories, because if members of the UPDF are not necessarily considered as the employees,
yes.
What are those categories? If you could define some of the worker categories, I don't know, is there a specific categories of types of workers that exist?
No, an employee is an employee. Regardless of the rank of the position you hold. At least when we are talking of the rights, we are looking at the rights that pertain to all of them, regardless of the category, provided that that person has a contract of service, meaning he has a contract with an employer. Then that is the employee we are talking about. Yes. All
right, then in that case, let's go into the rights, if we can, of those employees. What are some of the rights that people should know that are pretty much basic? Maybe like a right to fair pay, annual leave perhaps, the one that we all know.
Yes.
What are some of those key rights every employee in Uganda should know under the law?
Oh, thank you very much. I think that is the subject of our focus this morning, to try to highlight some of the rights the employees have. Because some of the employees don't actually know that they possess those rights. Therefore, they don't come to enjoy them. So generally, what is a right? A right is a set of protections or benefits an employee has. So what benefits do you derive as a result of the work that you do with the employer that you have? or what protections do you have? As you said, most of them no, pay, and then leave.
Yes.
But others don't even get those ones. So we will go through a few of them and see if you are enjoying them, and if you are not, at the end of this discussion, you should be able to demand for them because they are given to you by law. So one of them is work. So when you give me a job here to come and work for you, then you should be able to give me work. You don't just give me a contract, I come here and I'm redundant. So an employer has a duty which becomes a right on the part of the employee to do the work for which he was hired or employed to do.
I'm sure there are many people who would be happy to be hired and not to work.
That is, what can I say? That is morally wrong.
Yes.
You see, you must give value, a consideration. You must give something in exchange for something. Pay for no work is not morally right. You should be able to give some value for what you are paid to, for what the money you receive in exchange. So number two, the one that we all know and we cannot do without is pay. That once you employ me, at the end of the day, you have to pay me. And I think there is no question about that, because what happens is if you are not paid, you choose your response.
Yes.
Many people choose to walk away. And the non-payment is actually a constructive termination. And a person can walk away if he has not been paid for what you agreed.
But we know that many people are more afraid to walk away from any situation like that. I mean, we've seen in different scenarios, per se. You can't necessarily say proven, but I think we have heard of situations where people's pays have been delayed for several months and have been, I guess, promised that they should remain. The money is coming. And I think Uganda has heard that story many times. What about in that case, when Ugandans just choose not to adhere to the right they have? If they're not getting paid, they should leave.
That is true. There can be a delay because you as an employee, you would be able to understand the financial situation of your employer. So he's not deliberately refusing to pay you on time.
But eventually it is, isn't it? Because, I mean, if a person has never been paid, let's say, for a year and comes up, or is there a limitation to the time?
That is unreasonably too long.
Yes.
There is the responsibility on the employer is if you've entered into a contract of service with an employee, if you agree to pay him daily, you pay after the end of the day. If you agree to pay weekly, you pay after the end of the week. If you agree to pay after fortnight, you pay after the end of 2 weeks. And if you agree to pay monthly, then at the end of 1 month. When you take inordinately a very long time to pay up the salaries or the wages of the employee beyond maybe 2 months, the employee has an option. It's an option. He's the one who can exercise it to treat the employment as terminated and go and do something else. But if he knows that the employer has some financial difficulties and he's optimistic that he'll get paid, then he's free to stay on until the employer can settle his matters and pay up. And they usually pay, by the way. Sometimes they arise from technical problems, sometimes they arise from cash flows, but they pay. So we are not saying terminate immediately, no. We are saying if a year is a very, very long time. How do you survive?
To be honest, even 2 months is too much.
Yeah, sure. If you are in the shoes of the employee, if you know when you tell me I'll pay after 1 month, I know at the end of the month I'll get paid, and so I'll be able to defray some obligations. Yeah. So it certainly it is part of the responsibility of the employer to ensure that he pays the employees in a timely manner.
Let's talk about the sick and maternity or paternity leave. which in many times I think has brought up interesting conversations, I should say, especially when it comes to paternity leave, which is about 4 days, and maternity leave, obviously, the usual 60.
But do the listeners know that male workers have a right to take off time when their wives deliver, or in case they get a miscarriage? And how much time do they have? So, one, we would like to inform you that it is a right of an employee, a male employee, to have paternity leave when his wife delivers or gets a miscarriage for immediately for 4 working days. Working days, that excludes weekends and public holidays.
Okay, in that case, then we know.
Then maternity leave for female employees is almost like a given. I believe every employer worth the name knows that female employees are entitled to a break when they deliver or when they get a miscarriage, and what they only need to know is for how long. It is for 60 working days. Working days excludes weekends and public holidays. And when we say they get leave, it means they get leave with full pay. A person goes off to nurse his baby, and then you have to pay all the entitlements the person is supposed to have during that time when he's away.
Yes.
And when he comes back, he's entitled to resume the position he has held.
They were.
Or an alternative. If, for example, it is something that cannot wait, it's an operation where you really need to get a substitute, then he should get to an alternative position on no less favorable terms like the ones he held before she proceeded on leave.
It's always very good that we remind ourselves of the rights that we do have as employees. But in the same way, in the same breath that we can talk about the rights that we have, we can also talk about how these rights can possibly be abused. What does an employee do when those rights that are according to the law are abused? The pay, the leave, the maternity, the paternity, all of those intricacies when it comes to employee rights. What does an employee do when those are infringed on or even abused?
Vicky, I hope we'll come back to explain a bit more of the rights. Those are not the only ones. That is a tip of the iceberg.
Yes.
But there are certainly remedies. Once you have a contract, it means there is an obligation on both sides. There is an obligation on the part of the employer. There is an obligation on the part of the employee. And any breach entitles to the wronged party to a remedy. And the remedies in terms of employment are really you start from the labor officer. The office of the labor office is established in every district, in every municipality and a division of a municipality and a city. There is a labor officer there, that's where you go. And when you cannot get a solution from that point, then you can appeal to the industrial court. That's how matters of...
Yes. No. There's a question that I know many would love to know, especially when it comes to working hours. What is the legal limit per week, and how is overtime treated?
That's very good. Working hours. When an employee is engaged, unless the contract stipulates otherwise, the presumption is that he's going to work for a 48-hour week. And he must not exceed, within that week, he should not work for 7 days. He should have at least a day of rest. And the hours of work, you can choose when they should be. If it is a shift, that can be stipulated, but they should not exceed 8 hours per day, assuming you work 6 days a week. So which puts it at 48 hours.
Absolutely.
But there are circumstances when a person has to work longer. In any case, they must not exceed 10 hours per day, and that makes it 56 hours a week. Although it is possible for a person to work for more than 10 hours a day.
We've seen that.
Provided in 3 weeks, the average is does not exceed 56 hours, and at least in 48 hours, it does not exceed those 10 hours.
Okay.
So meaning
Now,
you can work a little longer, then on another day, you work a shorter period.
I mean, let's talk about how overtime should actually be treated under the law, because I don't think many employers adhere to any overtime, anything for that matter. Or maybe let me say for the few that we do know, how should overtime actually be treated? Because I don't think many people know.
So we have said any time beyond the maximum hours of work is overtime. So, and that overtime entitles an employee to remuneration, to pay for the time he has worked as overtime. Meaning, if it is on an ordinary day when the person is supposed to work, the remuneration for overtime is 1.5 times the daily rate of the normal working hours. If it is on a public holiday, then that person is entitled to have the overtime paid 2 times the rate of the normal working hours. For example, we are going to have Labor Day tomorrow.
Yes.
If you work on Labor Day tomorrow and they do not substitute it with another day of rest for you, you would be entitled to overtime at 2 times the rate of your normal
Many
working hours.
employees will not fight it in any kind of way if that was the case. We know of many that do work under those conditions, public holidays or overtime, and who probably do not get compensated. My question then is there a way they should be pursuing this or not? Because some of them are just afraid.
No, largely it is a lack of awareness. Many people do not know that they have this obligation. Because if they know, then they would be able to structure or to arrange their workers in such a way that they don't accrue overtime or only accrue it when it's absolutely necessary, because they know that will increase their cost of doing business, because you must pay this employee.
But it's not every institution in that case that can't work during public holidays, like institutions like the police, for instance. Those very necessary works. Do they also take days off on public holidays?
Incidentally, I've told you who's excluded from the application of this law.
Yes.
And that is only a member of the UPDF. Police is part of the public service of Uganda, so they're entitled to this. So if they know, they know, and therefore they know what to do. Yes.
Okay. Well, in that case, then let's clarify the rules when it comes to termination, because I want to move quickly into that area. Notice periods for termination, contracts in that case, unfair dismissal. Those are some of those things that many employees think about and worry about.
Once you have a contract with an employer, you are guaranteed to work until your contract expires or is terminated in accordance with the terms of that contract. And if it is terminated in any other way other than those terms agreed upon, then it becomes an unfair termination, and you would be entitled to compensation for that. Now, the only thing is also an employee can do wrong. If you do or you misconduct yourself in such a way that you cause a breach of your contract. For example, you abscond, you stay away from work for a long time without permission or reasonable cause, then the employer would be entitled to terminate. or if you commit a crime at a place of work, misconduct such as fighting, disorderliness, and stealing from or destroying things of an employer, that also goes to the foundation of your contract, a breach, and that means you can be summarily terminated. Yes.
Now, what about the right to join trade unions or even participate in a lawful strike?
That is the right of every worker to join a trade union. So trade unions help workers to protect and also to bargain for them on their behalf. You alone might not be strong enough to bargain with a strong employer, but when the trade unions come together, they try to bargain collectively for employees, say in a given industry, to have fair terms for them. So it's a constitutional right for everyone to join a trade union. Relatedly is industrial action. We call it industrial action. Is to protest. If the employer is not offering what he either promised or is not being fair to you in any way, you're entitled to protest in a lawful manner. So a lawful manner means there are procedures you must follow if you want to go on strike. As long as you keep it peaceful, you are engaged, you follow the law, that is your right, and you cannot be terminated because you participated in a strike. If the employer does, that becomes a wrongful termination and you'll be entitled to compensation.
Let's talk about workplace safety as well in that case, and even some social protection. What should employers provide in terms of a safe working environment and some social security as well?
Okay. In terms of safety, the environment must be conducive for an employer to work, and it does not injure the health or the person of the employer. So you have to provide that environment, and there's an elaborate law, and also that is one of the work the labor officer is supposed to follow through. So if the environment is not safe, I think the workers can raise an alarm to the labor officer to come and inspect, and they put it in place. But also we have social protection, and I think this is where many of us fall short. As employers, social protection is for the benefit of the employee when he's at work. So we know that indeed there are many employers who don't contribute for their workers to say NSSF. But there are other alternatives to NSSF. Some organizations have been permitted by law to operate superannuation funds. These are retirement schemes which are organized and run with approved schemes. There are a number of them which are regulated by UBRA. So those ones are allowed, but we know there are some who are not saving for their workers anywhere. The law now requires that even if you employ one employee, you should contribute or you should register with the National Social Security Fund for the benefit of that worker.
No, absolutely. Tomorrow, like we said, we are celebrating that Labor Day. What do you want Ugandans to know regarding that, and how are we celebrating in that case?
Thank you very much. Tomorrow we celebrate Labor Day, the day we celebrate in commemoration of workers like you watching and me, if you have a contract of service. So what do we want to know? What I'd like you to know is those rights we have mentioned and many others under the Employment Act in Uganda. It assures good productivity. It assures gives some stability to the worker when he is working. It gives some guarantees. It's important to wake up knowing that I have a contract and this contract will not be arbitrarily terminated. It gives some kind of assurance for you to plan well. So if we have not been observing those rights, let us observe them. But also, whenever we talk of rights, the obligations. So even as workers, employees, we need to keep the part of our bargain, to work diligently, to really give value for the pay that you receive, and also not to harm the employer.
Absolutely. Thank you so much
Yes.
for joining us this morning and for that very insightful conversation, detailed and of course empowering if you did not know any of those particular rights that you have. Now, as we mark Labor Day tomorrow, it's very crucial that both employers and employees understand their rights and responsibilities. And to anyone, if you'd like to learn more or you need support, the Judicial Service Commission is ready to help, and you can visit them, and of course on the 8th floor of the Kingdom Kampala, or you can contact them on the toll-free number that is 0800 100 22102. And thank you for joining us again, and I think we need more and more and more of all of this information that needs to be totally out there. For me, Victoria Sabia, we'll be right back.
Thank you.